We're here to talk about the Employment Rights Bill, the government's flagship piece of legislation, introduced with great acclaim, or certainly noise, within 100 days of the government coming in. Now, this is one of the most seismic pieces of legislation, and the Chief of Staff for the Prime Minister, as was then Sue Gray, warned that this couldn't be done to the timetable that was set. But the system was sweated, the bill came in, but it's come in with a lot of work done mid-air. That's the Hansard Society's phrase. 5 consultations had to be launched immediately after second reading. In committee stage, we saw, 160 government amendments. Report stage, another 350 odd amendments, hundreds and hundreds of pages of additional text added after the bill's introduced. And that means there's a lot of uncertainty around this bill. So I'm here with our Stefan from our employment team to talk about that bill, a little bit more what's on it and what you might expect going forward. Stefan, can you tell us a little bit more about what you think about this bill and what's in it?
Of course, yeah, thanks, Nikki. Well, it's certainly ambitious. I mean, that's not in dispute. And I think the Hansard Society has been quite kind, saying that they're making changes mid-flight. I mean, the sheer volume of legislation in this bill is just is mind-blowing, even for employment lawyers. So goodness knows how employers or business are feeling. And the recent changes, I think if you take them one by one, maybe not an issue, but they're not. They're being put through in one go, and the volume is staggering. I think if we focus on just a couple of them, take the ban on 0 hours contracts, which has now been extended to agency workers. That's going to have a huge impact on agency workers and employers who use agency workers. The day one rights in relation to unfair dismissal are also very unclear. What's actually going to be required in practice during that initial period, and the sort of slightly stealthy extension of trade union rights in terms of the ease with which they can access the workplace and their rights to call industrial action. Again, they've been extended massively. And I think what the challenge that I see for many clients is that despite the volume behind this bill, it's still not clear how those changes are going to be implemented in practice.
It's interesting you should say that, because Lord Hermer, the Attorney General, he came in and said he wanted government to do legislation differently. He wanted to redress the balance between Parliament and the executive. But we have a situation here, and I'm a little alarmed because I was hoping that you would read this bill and it's really easy to understand it. But to hear that that's a problem for employment lawyers, can you tell me a little bit more about what the lack of scrutiny means in terms of clients and organisations having certainty in this regard?
Well, it's creating a massive lack of certainty for employers, because even if they don't like the changes that are being brought in, if they knew what they had to do to actually comply with the new law as and when it comes in, then that would be something. But at the moment, that they don't. So take the ban on 0 hours contracts, for example. That runs to some 30 pages of the bill. You'd think 30 pages, there's a lot of detail in there, you must know. But we're none the wiser as to how in practice it's going to work. So, over what period are people going to have to work to be able to have a right to guaranteed hours contracts? That period's not clear. And if you're trying to plan for how you're going to use agency workers in the interim, you just still don't know what you have to do. And I think it's the uncertainty that is a massive challenge for employers. Take also the unfair dismissal day one rights. Again, there's a lot more detail in there than there was when the bill was first published. But we don't know how in practice it's going to operate. We're told there will be a probationary period, an initial period of employment. We still don't know how long that's going to be. We don't know what process an employer will have to go through to dismiss someone fairly during that period. And we don't know whether, if they do and they're found to have unfairly dismissed them, whether it's going to be the full compensatory award that would apply to people who have currently 2 years service, or something different. So I think from my perspective, it's just a massive lack of certainty is going to be the challenge for employers and business here. What we have seen, which I think is positive, is that in relation to some provisions, for example, collective redundancy rights, where the original proposal had been to abolish the requirement for there to be 20 redundancies at any one establishment for the collective consultation obligation to apply. The government does appear to have listened to business, and they've watered that down, they've toned it down potentially significantly. So they are prepared, I think, to make changes where business have points to make. And I think what I would be really keen to hear is your view, Nikki, as to what scope you think there is for business to influence the bill prior to it becoming into law.
And I think it's really interesting that you say that the government is willing to listen, because the bill now moves to the House of Lords, and that's really where the government does have to listen. The rules of the game are really different in Parliament. In the Lords, there's no programme motions, there's no guillotine. Every amendment that's tabled can be debated, can be voted upon. There's none of this sort of narrowing of focus that happens in the Commons. And that means that issues can be exposed. And because peers are often more interested in going into the detail, they can push things. And that means that when you have a number of issues put forward to government has to think. And I know from my experience in number 10, there were times when actually I started to realise, do you know what? We were so certain we'd got it right. And actually what they're saying in the Lords is correct. We have made a mistake. And officials would then start to go, oh, yes, we agree. And so there is time. Second reading is on Thursday. Then it will go into committee stage. And there's no votes there, but there's lots of opportunity to air issues. And so for organisations that want more clarity, even if it's just ministers saying at the dispatch box, this is our intention, that's a really important moment. And then going forward from that report stage, again, quite an extensive stage where you can push issues. There is so much potential to get greater clarity in law through the House of Lords, and for those issues to actually be refined, not just leaving voids in the legislation. So I would say that if you are talking to clients about, I would say look at what that needs to happen. Where are the uncertainties, and do make use of the Lords.
Thank you.
Thank you very much.